I'm David Ruskin. I'm an adjunct professor here at the law school. When Professor Bartell deems it appropriate, occasionally I teach bankruptcy here. Thank you, Professor. Appreciate it. Welcome to a special edition of our class today. We're normally at 125 to 250. We have a few people here today from our class. Would you raise your hands so we can identify? Okay, so now we know who the usual suspects are. Okay, thank you. We do have a sign-up sheet going around, so students, please make sure, for those of you in our class, please make sure that you sign in. This is a regularly scheduled class. But that's where the regularity of today's class ends. We're very fortunate this afternoon to have with us Judge Steven Rhodes. Judge Rhodes, I guess I should say retired Steven Rhodes, although he's still Steven Rhodes. Is the bankruptcy judge that presided over the country's largest Chapter 9 municipal reorganization case. Judge Rhodes had been a bankruptcy judge for about 30 years, and I had the privilege of appearing in front of him for much of that time, and I had an opportunity to watch him and to observe. And I think I can safely say to you that you're in for a real treat today. To be assigned to the country's largest Chapter 9 case is certainly in itself a historic event. To carry it off with the degree of success that the case has been, and in the fashion that Judge Rhodes has contributed to that success, has really been amazing. Watching him on the bench, you have an opportunity to see the engineer in him with his undergraduate degree, parse through all the various different legal issues, and yet at the same time you could look carefully, you could also actually watch him as he dictates opinions as he speaks from the bench. It's a treat, it's an honor, and I'm sure that you'll all enjoy the presentation that he has for us today. So without any further ado, Judge Rhodes.
Thank you, David. So what I'm going to do here this afternoon is talk to you for a piece of time, and then I'm just going to open it up for your questions and encourage you to ask me any questions about the case that you'd like to ask. What I'm going to do here in this talk is address how we got from the beginning to the end of the case and how we did it in 17 months. I want to talk to you about the range of challenges that I faced during the case, about what I did right in the case, what I wish I had done differently. I'll talk to you about the mediation process, the grand bargain, a little bit about the work of the emergency manager, Kevin Orr, the lawyering in the case, the media coverage, how I dealt with the pressure of the case on a personal level. So here are the 4 keys as to how we got from the beginning to the end of the case in 17 months. Number 1, my strong judicial management. Number 2, persistent and innovative mediation. Number 3, really good lawyering. Number 4, a widespread belief in the city's mission. So let me address each of those. First, in the litigation in the case, my judicial philosophy was pedal to the metal. This was a matter of survival for the city. The city absolutely needed to get out of bankruptcy as promptly as it could. It was also a matter of survival for me personally. At times, the parties filed tsunamis of motions, objections, responses, briefs, adversary proceedings. And I had to resolve them promptly just to keep from drowning in them. All of this was consistent with my own judicial philosophy over my years on the bench, which I'm sure Mr. Ruskin will testify to. I actually stole this from a movie. Glenn Gary, Glenn Ross. Have any of you seen that? Yeah. It's ABC, always be closing, always be closing. This philosophy holds that every case management decision, every date, every deadline in every case management order is based on this philosophy, always be closing. It's biased against delay and in favor of closing the case. Always be closing. Now, of course, the primary obstacle to always be closing is what? That pesky little thing we call due process, right? I tolerated only one exception to always be closing. I will always honor a request from my mediators to apply the brakes to some litigation when they advised me that mediation would be facilitated by holding off on litigation. I did that because I knew that a mediated result in the case on any issue would always be better for the parties than a litigated result. Still, mostly we ran mediation and litigation at the same time, simultaneously. So the smartest thing I did in the case was to appoint Chief Judge Rosen to be the mediator in the case. That job required the right combination of weight of office, love of the city, political and community connections, relationship skills, communication skills, thick skin, innovation, and relentless personality. And Judge Rosen has all of that. He put together a magnificent team of mediators, including 3 other district judges, Victoria Roberts, Sean Cox, and Wiley Daniel from Colorado, my colleague, Bankruptcy Judge Elizabeth Harris from Oregon, and Eugene Dreiker, who you all know from his connections with Wayne State Law School here. Judge Rosen and that team deserves much and perhaps most of the credit for the ultimate success of the case. When I appointed Judge Rosen, I told him that his deliverable to me was a confirmable plan, and he delivered it. In the end, there was very little left for me to decide in the case, although you might not actually know that from reading my 213-page confirmation opinion. The key settlement in the case, of course, the one that started the dominoes falling, was, of course, the grand bargain. I have called that accomplishment miraculous. It was. It was unprecedented in the history of mediation and unprecedented in the history of bankruptcy. Judge Rosen went outside of his role in just mediating disputes between the parties and solicited over $600 million from charitable foundations and from the Detroit Institute of Arts for the city's pension plans. He also went to the governor and the state legislature to persuade them to appropriate nearly $200 million. The deal will bring to the city's pension plans $816 million over 20 years. The deal also placed the art in the Detroit Institute of Arts into a public trust and protected it from endless creditor litigation. It also preserved the city's pension benefits at nearly, not quite, but nearly pre-petition levels and settled all pension issues in the case. After the grand bargain, Judge Rosen and his mediation team relentlessly, creatively, and successfully pursued settlements with the retirees on their health care claims and the financial creditors' claims. Each settlement resulted in a new amended plan, and the final confirmed plan was the 8th amended plan. That last plan settled the claims of the city's 2 fiercest plan opponents, Syncora and Financial Guarantee Insurance Corporation. We called it FIGIC. Judge Rosen mediated particularly creative settlements with those creditors. Because those creditors were the last to settle, the city's financial cupboard was quite bare, and there was very little room left in the projections to pay them much from future revenues. So he found a way to bring them in with win-win solutions for all sides. The city gave Syncora and Fitchick opportunities to develop specific city properties. In the end, almost every creditor class overwhelmingly cast their ballots in support of the plan, including the pension classes. The only classes that voted to reject the plan were two classes of general unsecured creditors. Now, I assumed that Judge Rosen was done when I confirmed the plan, but no. At that point, you may recall, the mayor began publicly squawking about the fees in the case. By then, the fees had totaled over $190 million for all of the professionals that the city was obligated to pay, and the mayor thought that was too much. I was prepared to resolve the mayor's issues through litigation, but Judge Rosen jumped right in and spent hours with the city's attorneys and each group of professionals mediating settlements of all of the fee disputes. So like I said, appointing Judge Rosen was the smartest thing I did in the case. The third factor that allowed the case to complete in 17 months was really good lawyering. So what made it so good? There were all the usual things that we judges crave. Briefs that were cogent, well-organized, timely, and well-organized. Oral arguments that were well-organized and that anticipated and answered my questions. Stipulations were possible. Exhibits that were well-organized. Witness examinations that were crisp, to the point, and within the time limits that I set. But two other things about the lawyering also stood out. The attorneys were extraordinarily civil. It was downright pleasant to be with them in court. I liked it. It was even fun sometimes. But don't misunderstand me. They advocated zealously for their clients, and in the process, they proved that zealous advocacy and professional civility are perfectly compatible, even symbiotic. The other thing that stood out about the good lawyering in the case was that the lawyers had the triple play of skills necessary to be really good bankruptcy lawyers. These skills are first, good litigation skills, second, good negotiation skills, and third, the good judgment to know when to litigate and when to negotiate. At the conclusion of my opinion in court confirming the plan, I told the lawyers that the work in the case was an exemplary model of the public service role that lawyers perform in our society. The last of the four factors that allowed the city to exit bankruptcy in 17 months is one I've only recently come to understand after the intensity of the case has subsided. I began to ponder, why did creditor after creditor settle and agree to adjust its debt with the city on terms that the city could afford? When the governor authorized the filing in the summer of 2013, you will recall there was great anger in the city. Anger at the filing and anger at the appointment of an emergency manager. Many people felt that was unnecessary. So why, after such anger, did the employees and the retirees overwhelmingly accept the plan and agree to endure the personal sacrifice that the plan would require of them? And later, why did the financial creditors, whose litigation asserted that Detroit's plan would mean the end of municipal bond market as we know it, why did they agree to give up that litigation and accept anywhere from 10 to 70% on their claims? And why did the state of Michigan and a collection of foundations come together to contribute $816 million to the city? Now, certainly there was a strong measure of self-interest to each of their settlement decisions. Let's not doubt that. But I think there was more to it than that, much more. I have come to believe that a big reason for this happening is that the mission of the city of Detroit is to help people. Police help, fire help, emergency medical help, water service, transportation service, recreation, culture. I believe this basic mission to help people is what compelled the city's creditors, the state of Michigan, and the foundations to help the city. To help the city was to help the people in the city who desperately needed help. In this country, we believe in the obligation of community to promote the dignity, welfare, and opportunities of its residents and its visitors. We believe in the mission of the city of Detroit. It's who we are. We also love to give people a second chance, a fresh start, to forgive them. And that's, of course, what bankruptcy is all about. Let me now address the challenges for me in the case. Actually, let me first address matters that got a lot of publicity and that you might think were challenges, but really were not challenges. The first was my holding in my eligibility decision, holding that the Michigan constitutional prohibitions against impairing municipal pensions does not prevent a municipality from seeking to impair pensions in bankruptcy. As a legal matter, I never thought that this was a particularly difficult decision. Although our Michigan Constitution states that pensions shall not be impaired, it states that pension claims are contract claims, and impairing contracts is, of course, what we do in bankruptcy all the time, day in and day out. The second in this category of non-challenges was my finding that the city was eligible to file a Chapter 9 case. Unlike any other debtor that files a bankruptcy case, a Chapter 9 municipal bankruptcy debtor must prove its eligibility. It must establish that it is insolvent, that it desires to file a plan of adjustment, that it either negotiated in good faith with its creditors or that it was impracticable to do so. Also, when challenged, it must also establish its good faith in filing the case. Despite all the anger in the city about the filing and the large number of serious objections that were filed, this was not really a tough decision. A finding that the city was ineligible and the resulting dismissal of the case would have meant disaster for the city and its residents. There really was no choice. The third in this category related to the art at the DIA that I mentioned earlier. The city technically owned the art. The value of that art, at least potentially, is hundreds of millions of dollars. The consensus in the art world is that the DIA collection is the country's sixth best art collection. It is truly magnificent. Creditors wanted the art sold, or at least appraised for confirmation purposes. The Michigan Attorney General and the DIA itself vigorously opposed any sale or monetization of the art, arguing that it was in a public trust. After some initial waffling, the city also opposed the creditor's motion or position on the art and announced that it had no intention to sell or otherwise monetize the art. My decision was that it was inappropriate to consider the art in determining whether to confirm the plan. Three factors made that decision easy for me. First, Section 904 of the Bankruptcy Code prohibits the court from interfering with any decision that a municipality makes regarding its property. Second, the decision on the city's part not to sell the art or otherwise monetize it was the right decision. I said in my confirmation opinion, quote, "To sell the DIA art would only deepen Detroit's fiscal, economic, and social problems. To sell the DIA art would be to forfeit Detroit's future," close quote. Third factor that made this easy for me was that outside of bankruptcy, nothing in Michigan law would give any creditors access to the art to pay on their claims. So the best interest test for confirmation would not require that consideration. The result in the case is that the DIA art stays where it is, and that was not a particularly tough decision for me. Let me now address the challenges that I did face in the case and how I addressed them, how I dealt with them. And you will see as we go through the list that some of these challenges align with those areas where Chapter 9 is different from Chapter 11. Have you all studied Chapter 11 yet? I'm seeing some vague nods of the head. I see a denial by your professor. Whatever. The single most challenging aspect of the Detroit case for me was the fact that it was as much a political case as a legal case. What made it a political case was that everyone in Detroit, even in the state of Michigan, had a personal and direct stake in the outcome of the case. This is what, of course, motivated the intense media interest in and scrutiny of both the proceedings in the case and me personally. So the challenge, as I saw it, and I repeatedly articulated it to myself, was to establish and maintain throughout the case my legitimacy as a fair and neutral arbiter of the facts and the procedures and the law in the case. I had very little precedent on how to do this. I knew, or at least strongly suspected, that simply following the normal rules and doing the best I could would not be enough to convince the skeptical and angry public about this. I did, however, find this advice on how to establish and maintain judicial legitimacy. Quote, "Legitimacy is a tenuous commodity, particularly for unelected judges, like me." Close paren. Recent studies suggest that the public has serious doubts about the legitimacy of the courts. At least some of the public's misgivings can be traced to the lack of meaningful participation by those who are affected by the court's decisions. When a court sets a precedent that binds third parties who never had any opportunity to shape the governing rule, it risks losing legitimacy in the eyes of the broader public. Close quote. So I took that advice. I decided that I needed to open up both the eligibility phase and the confirmation phase of the proceedings to everyone who was impacted by the case and wanted a voice. I invited their objections. I invited them to come to court and make their statements to me. I invited some to participate in the confirmation trial by presenting evidence and examining witnesses. At the eligibility phase, 93 unrepresented parties filed objections, and 45 of them appeared in court to address me on a day set aside for that. At the confirmation phase, unrepresented parties filed 836 timely objections. I invited a cross-section of 79 of them to address their objections to me in open court, and 46 of them appeared. Although this was a bit burdensome, it sent a powerful message about the openness of the process and about the sincerity of my concern for the rights of everyone impacted by the city's bankruptcy case. I also learned a lot about how the bankruptcy was impacting the people of the city. It was the best I could do to bring democracy to the case. Equally importantly, to deal with this matter of establishing and maintaining my legitimacy, I gave the media as much access to the proceedings as I legally and practically could. Unfortunately, the Judicial Conference of the United States has a policy that prohibited me from permitting simultaneous broadcasting or webcasting of any of the proceedings. I felt that this was unfortunate because I thought that allowing that kind of broadcasting or webcasting would have helped me to meet the challenge of maintaining my own legitimacy. More importantly, however, I thought the public had a right to see its elected and its unelected officials testify in these public court proceedings about the matters that so directly affected their lives. These witnesses included at times the governor, the state treasurer, the mayor, and the president of the city council. It also included the police chief, the fire chief, chief financial officer, and the chief information officer. I wish that the media had made a more formal issue out of this so that we could have teed up the obvious First Amendment issue. In any event, my judgment is that the media did a reasonably good job of reporting on the case. When a mistake that needed to be corrected did occur, we would contact that media outlet and ask for a correction. And most often they would cooperate by making the correction in their online version of the story. At times, however, I was less pleased with the media's reporting of me personally. I did get a kick out of their odd fascination with my participation in my rock and roll band, the Indubitable Equivalents. But sometimes they spelled my name wrong or got other details wrong. One outlet reported that I was 73 years old. I didn't like that. But I especially didn't like it when one of Detroit's local papers described where I live, gave my daughter's names, and identified where they live. Unfortunately, the article was in print, so when the U.S. Marshals asked them to remove that information for security reasons, they could only do that in their online version. Nevertheless, on balance, I give the media a solid B+ grade for their reporting on the case. The next major challenge I had to face in the case was determining the limits of my jurisdiction due to the limitations in Section 904 of the Bankruptcy Code, which I mentioned earlier. That section says that unless a municipality consents, the Bankruptcy Court is broadly prohibited from interfering with any of the political or governmental powers of the debtor and with any of the property or revenues of the debtor. Its meaning and application was a challenging issue throughout the case. It came up in the eligibility phase when the city sought post-petition financing, on motions to approve settlements, and certainly throughout the confirmation process. Most publicly, Section 904 came up in connection with the water shutoff lawsuit. Most of you probably read about that. In 2013, the water department began to shut off residents' water for failing to pay their water bills, and by the late summer of 2014, it was thousands of customers. I felt that these shutoffs were causing real hardships in the city, and that it was a public relations nightmare for the city. I thought that the city had totally mishandled it. After I questioned city officials about this in open court, the city got a bit more organized and announced a 10-point plan to ease the hardships and to make financial help more readily available. The ACLU filed a lawsuit seeking a preliminary injunction to stop the terminations, claiming due process violations, executory contract violations, and asserting several state law claims. Upon the city's motion to dismiss, I had to agree that the state law claims were barred by Section 904. I also agreed that the executory and due process allegations failed the state claims upon which relief could be granted. I held that there was no constitutional right to affordable water any more than there is such a right to affordable housing or food or heat. I also held that a customer's purchase of water from the city was not pursuant to an executory contract because all its terms are fixed by law. I had very mixed feelings about this outcome, however. Obviously, people need water to live. Unfortunately, the evidence established that the city's 10-point plan didn't go far enough in helping people who needed help paying their water bills because the help was difficult for them to access. On the other hand, the case had all the red flags of becoming both a political and management nightmare that would sidetrack both me and the city just as the confirmation trial was getting underway. I faced a real challenge when Judge Rosen mediated a settlement and then publicly recommended that I approve that settlement that he had mediated. The problem was that after a hearing, I found that I could not approve that settlement. Let me give you a very brief synopsis here. In 2005, the city entered into a disastrous debt transaction to shore up its underfunding of its pension plans. One feature of that transaction was an interest rate swaps contract intended to stabilize the city's interest obligation on that deal. By 2013, when the city filed bankruptcy, the city had a termination liability to Merrill Lynch and UBS of about $230 million on that swaps contract. The settlement that Judge Rosen mediated was for $169 million. The city filed a motion for my approval of that settlement, so I held a hearing to examine the usual settlement considerations. I found that the 2005 transaction that ultimately resulted in this swap's termination liability was quite likely illegal, ultra vires, and one on which the city might have no liability at all. Why? Because it was deliberately structured to evade the city's debt limits under state law. In fact, it was so creative that it won Bond Buyer Magazine's award for Transaction of the Year, Most Innovative Transaction of the Year. In any event, my judgment was that a 73% settlement on a claim that was likely to be disallowed was just too high, so I disapproved it. That was very tough for me to do. Judge Rosen and his mediation team certainly didn't like it. As a result, we had what he called a full, frank, and candid discussion about our respective roles in the case. In the process, however, something happened that I did not foresee. The media and the public heaped accolades on me for standing up to Kevin Orr, his lawyers at Jones Day, and those big, bad Wall Street banks. That single decision probably did more to establish my legitimacy than anything else I did in the case. By the way, months later, after more litigation, the parties settled at $88 million, and I did approve that. Another set of challenges resulted from the fact that the language of municipal bonds and municipal bond law is different from the language of the Bankruptcy Code and the Uniform Commercial Code. Each of the bond classes, and there were several, sought rulings from me that under their bonds and under municipal finance law, their claims were entitled to secured status, or at least to some preferred or priority status. We got to arguing over the several conflicting meanings of the word pledge, or what it means in bankruptcy when a bond obligation is a, quote, first budget obligation, close quote. At one point, my law clerks and I counted 8 different legal theories that the holders of the limited tax general obligation bonds were arguing in support of some sort of priority. I almost concluded that because of the fact that they needed so many theories, it probably meant that I should reject all of them. In any event, all of these bond classes eventually settled, thank you, and there was little left for me to resolve in dealing with these complex issues. The final set of challenges came at the confirmation stage. In its confirmation requirements, the Bankruptcy Code, Chapter 9, sometimes uses the same words as Chapter 11, and sometimes Chapter 9 incorporates by reference some of the Chapter 11 plan confirmation requirements. Nevertheless, the Chapter 11 words and requirements often have different meanings and apply differently in Chapter 9. For example, in Chapter 11, the best interest of creditors test is simply a liquidation test. The debtor has to pay more to creditors than they would get if the debtor were liquidated. But in Chapter 9, there can be no liquidation. You don't liquidate municipalities. So what is the best interest of creditors test in Chapter 9? Similarly, under Section 1129B2 of the Bankruptcy Code, the test to cram down a plan on a dissenting class of unsecured creditors is what we call the absolute priority rule. Have you studied that? No. That rule says that shareholders cannot retain any value in a plan unless the unsecured creditors are paid in full. Under Section 901 of the Bankruptcy Code, that section does apply in a Chapter 9 case. But there are no shareholders in a municipal case, right? So what's the rule to cram down on unsecured creditors in a Chapter 9 case? Similar ambiguities arise with the fair and equitable test for confirmation and with the feasibility test. In fact, my greatest concern in connection with confirmation of the city's plan was feasibility. That concern led me to appoint my own expert witness on feasibility. I did this because I did not want to later be known as the judge on Detroit's first bankruptcy case. So, under Rule 706 of the Federal Rules of Evidence, I appointed Marty Kopes, from Phoenix Management as my expert, and the city agreed to pay her fees. Under enormous time pressure, she and her team thoroughly reviewed the 10 and 40-year projections that the city's experts had prepared, and she credibly summarized it all in her report for me. In the end, she concluded that the city's final plan of adjustment was feasible, although barely so. I accepted her findings and conclusions almost completely. Let me conclude now with a word about what in the case I regret. My biggest regret relates to the city's pensions. For what I assume are largely political reasons, municipal pensions in this country are mostly defined benefit plans. This type of plan places all investment risk on the municipality. Private employers in this country and many public employers in Europe have long since moved to defined contribution plans to minimize and even eliminate employers' risk. In my judgment, the city of Detroit should have used this bankruptcy case to accomplish that goal, but it did not. Instead, the city's settlement with the pensions established a kind of a hybrid plan with mildly reduced assumed rates of return. As a result, the city still bears substantial risk that its pension plans will underperform and leave it exposed to a liability that it cannot afford while it is trying to revitalize itself. Unfortunately, although I felt this was a lost opportunity, it was clear enough to me that there was nothing I could do about it. The pension settlement and the plan provisions incorporating the settlement met the requirements of the Bankruptcy Code, and then there is also that pesky section 904 of the code that prohibited me from interfering with the city's property. The case was a dream case for me. Great issues, great lawyers. It was my honor to serve on it. Now I'm glad I'm done with it. Thank you. Let me now take your questions. Who has a question? First hand. Yes, sir.
Hi, Your Honor. My name is Eric. I'm a 3L here. You wrote in your ruling in November that, quote, it's now time to restore democracy to the people.
Yes.
I thought this was quite a remarkable statement, legally speaking, because it asserts that the government has the power to suspend and restore basic fundamental rights guaranteed in the population. But in the American Revolution, the question that was fought out was whether democratic rights were inalienable or whether they could be handed down and rescinded at the prerogative of the king or his peers. And it was Jefferson who wrote in 17...
Is there a question coming
Yeah,
along here, sir?
There is. Just give me 1 second. Because
Let's get right to your question.
Sure. He said that there's that a free
What's the
people's
question,
blank.
sir?
How do you reconcile your... First of all, I think it would have been better if you would let me finish my question. But the
We
brief
have
question
time
is...
and lots of
So
questions.
the brief
What's your
question is, how do you reconcile your statement about the ability of the court to grant and rescind democratic rights with the fundamental principles of democracy?
Well, the premise of the question is of course, wrong. The court did not suspend any democratic rights. What I was referring to there was the fact that the emergency manager had been appointed by the governor pursuant to PA 436, and the effect of that was to suspend the authority of the duly elected mayor and the duly elected city council to perform their obligations and to be accountable to the people who had elected them. And so what I was referring to was the fact that upon the conclusion of the bankruptcy case, it was time to restore that feature of democracy to the people of the city of Detroit. In connection with eligibility, I was asked to find, on the grounds that you so eloquently assert, that PA 436 was unconstitutional. I rejected that argument on the grounds that the city is an arm of the state, and it's a creation of the state, and whatever the city does or doesn't do with its property and with its obligations is subject to state law as enacted by the legislature. And the legislature has the authority, therefore, to expand or contract a city's structure however it sees fit. And by enacting PA 436, that's what it did. So I found that PA 436 was therefore not unconstitutional. It was, upon the conclusion of the case, however, time to restore full democracy to the city. Question? Yes, sir. Okay,
Because
next.
when you realized that you would be the judge trying this case, and you knew that you're kind of going into uncharted waters, how did you develop a plan to move forward, like to move your way through the case?
You mean sort of administratively?
Yes.
Well, that's a really interesting question. When I first got the case, my own chief judge, Judge Shefferly, volunteered to have the rest of my docket taken over by the other judges. And I said, well, let's see how it goes before we do something drastic like that. Well, it took about a week. And I was getting this, what I call tsunami of motions, that I decided to accept the judge's offer. So this was my only case from then on. I also asked for additional law clerks. I had 2, and I asked for 2 more, and the Sixth Circuit, which had appointed me, granted me that. So I had all of the staff support that I needed. I had a wonderful judicial assistant, and of course, the district court provided me with the facilities that I needed to conduct the case. Our own courtrooms in Bankruptcy Court, which are across the street from the federal courthouse, were much too small for the case. They very generously gave us the biggest courtrooms in the building to conduct the hearings, and most of the time they were full. They also had a separate media room with closed-circuit TV, so they could watch and listen to everything that was happening in the courtroom without disrupting the proceedings. But in terms of an overall plan, it was really very little more than what I explained, which was pedal to the metal and keep it going. I just knew that the city needed to get out of bankruptcy as promptly as it could, and I knew that the city needed to get its full democracy restored to it as promptly as it could. You were next, sir.
Oh, good afternoon, Judge. Will Thompson with Real here. I had a question for you. Way back to the key decision. So when you found that the pensions were eligible to go through bankruptcy and kind of proceed with the whole process, if you could talk through hypothetically what would have been the outcome had you not found that the pensions were eligible to go through bankruptcy, what would have been the process for Detroit, or what would its financial outcomes look like now?
Okay, did you all hear the question? Okay. It's very hard for me to speculate as to what would have happened with the case if that decision had gone the other way. I say that because what allowed the city to be as generous with the pension claims as it could be in the end of the case was, of course, the grand bargain and the willingness of the foundations and the state to come in and fund it to the level that it did. Whether that funding or more funding or less funding would have been available in that hypothetical, I don't know. The state's contribution was motivated, at least in part, by its concern that because of the guarantee in the Constitution, the state Constitution, not to impair pensions, the state itself might have some liability, or even full liability, to make up any unfunded pension liability. So if the city had been unable to fully fund the pensions, there was some discussion about seeking redress from the state itself. And that would, of course, have taken years. The city could not afford to be in bankruptcy for years, and it would have been a disaster. So I don't know. It's hard for me to construct a scenario in which that result would have been good for the city. Which raises this point that I have to emphasize. bankruptcy requires shared sacrifice from most creditors. The only ones who we don't require sacrifice from are those creditors whose claims are fully secured by the property of the debtor under state law. And the lawyers, of course. Although in our case, there was some sacrifice on our part. Not inconsiderable sacrifice. But, yeah, it's hard for me to answer your question very specifically. Other questions, please. Yes, sir.
Jim Soshelski, 2L. Considering the unprecedented size of this case and the speed with which it was resolved, how do you think this is going to affect other municipal bankruptcies around the country going forward?
Okay. So the question was, how do I think this bankruptcy, or the way it was handled, will impact future municipal bankruptcies? Again, that's a very hard question for me to answer. The first thing I would note is that as far as I know, there have been no municipal bankruptcies filed since Detroit filed. In terms of legal precedent, except for the decision I made about the pensions, I don't really see any legal decisions that I made that might have any substantial legal impact.
Such as the example of the grand bargain.
Okay, so I was going to go there. So in terms of legal decisions, I don't see much that's portable to other cases. In terms of process, I do see a lot that I hope future cases will learn from what I do. And the concept of pedal to the metal, the concept of using a strong team of mediators, the concept of going to the community to access resources to help the municipality solve its problems. These are precedents that I hope other municipalities will see the advantage of using and will be able to use in their special circumstances. Because of course, every bankruptcy case, every municipal bankruptcy case is different. But absolutely, this is precedent setting in that sense. Yes. Other questions, please? Yes, sir.
In regard to novel legal issues and especially the pension decision, can you think of any specific authorities other than the state constitution that you found helpful?
And I found what?
Helpful in your decision?
There were 2 or 3 decisions of the Michigan Supreme Court after the 1963 Constitution, which had interpreted the pension clause and had stated that these were contractual obligations. So those also gave them country court. There was a decision by the judge in the Stockton, California case, which also paved the way for his holding, which I relied upon to some extent. Beyond that, in coming to this conclusion, I had sought the help of a constitutional law professor at my alma mater at Michigan to help me wind my way through all of this. And so her advice on this subject was also great. Yes, man in the back.
Hi, my name's Elena Bailey. I'm a 1L here. And so I'm a 1L, so I have a really lack of experience on this. But you talked about the water shutoffs, and you talked about the plan that Detroit had was flawed in some ways, and that you recognized that. And could you just explain why access to affordable water wouldn't be a constitutional right? Because I've only had Con Law 1, and we didn't touch on that. So what's the magic issue that makes something a constitutional right then? Because water, like you said, is pretty basic to life.
All right, everyone hear the question? Okay. So why is there no constitutional right to water or affordable?
Affordable water, yeah.
If you look at most of the Supreme Court's due process decisions, which is what we're talking about, due process, what they talk about is are the procedural requirements that a government must have in place and implement before it can deprive a person of their life, liberty, or property, right?
Yeah.
It's the pretty rare Supreme Court case that identifies what they call a substantive due process right. And there was no authority that I could find, or that was even cited to me, that said that any court had found that there was a right under the due process clause to obtain water from the government, either free or at a price that could be afforded. What the decisions talk about is what process the government needs to undertake before it can terminate water service. That's what the decisions talk about. And it's the stuff that you traditionally understand in procedural due process. A right to adequate notice, and a right to be heard before the action that the government proposes is actually taken. And so I looked at what the city does before it terminates service, and it struck me as perfectly consistent with the very minimal requirements of constitutional due process. Now, having come to that conclusion, as I said, I felt that the water shutoff problem was a public relations nightmare, and it was also causing real hardship in the city, and that the city could be doing much more, not as a matter of constitutional right, but just as a matter of fulfilling its own mission to its residents, to help them. Now, there were two specific flaws that I found. One was, that I mentioned, it was too hard for these customers, who were generally unsophisticated people, to figure out how to access the financial help that was available. It was a maze. You go here, and you go there, and you fill out this, and you fill out that, and there was very little reconciliation of all of the various sources of help, most of which were private. And so they were not coordinated. The second major flaw I found was that no one had done a study to determine how much money would be needed on an ongoing basis to help the people who needed help. And so there was no analysis of whether a collection of private funds that had been cobbled together was actually enough money to deal with the problem.
So I have a follow-up question then. So that makes sense. But going forward, what should happen then? Like, how should these people be helped? How would you suggest that we help the people who are going through life without access to water? How would you propose that we fix that problem?
Well, the two things I would recommend, and I did recommend on the record, was that all sources of help be centralized into one place where anyone who needed help would know to go to get help, and the process for obtaining that help be streamlined and simplified. And second, this study that I talked about a second ago needs to be done. I had a very strong suspicion that the amount of money that had been cobbled together, although generous, was not going to be enough money to help the people who needed help on an ongoing basis. Because, like I said, there were thousands of them, and many of their bills were very substantial, very substantial. Should we let Professor Vitale ask a question? Yes.
Yeah, hypothetical question. Judge Rhodes, would you have been willing, in the absence of the grant partners, to confirm a plan of reorganization for the city of Detroit that either provided significant cuts to pensions, or alternatively provided for the liquidation of the Detroit Institute of Arts in order to avoid significant cuts to the pensions?
Well, that's a provocative question, isn't it? Well, the law would have required me to consider any plan that the debtor had put forward, and the primary issues there would be whether the plan was, in the words of the the answer is yes. I was fully prepared to consider the confirmation of a plan that provided a much more substantial impairment of pensions. I said when I found that pensions could be impaired, that I would not take any such decision lightly, and I would very carefully consider it. But I certainly was not in a position to reject any such prospect out of hand. In terms of the art, I was fairly convinced early on in the case that the art was not in play. The reasons I identified. Creditors would have, including the pensioners, would have no access to it outside of bankruptcy. And I needed to be persuaded.
But if the city had decided to sell the liquid...
Oh, if the city had decided to sell it, I'm not sure that there was much that I could do about that under Section 94. Okay, there were some other hands, yes?
My impression is that there has not been a lot of Chapter 9 bankruptcy, and I suspect that Chapter 9 has not benefited substantially from revisions or amendments. It seems to me miraculous that Congress would have got the topic of municipal bankruptcy correct the first time. So my question is, based upon your experience, what changes in Chapter 9 must or should be made?
Well, of course, it's miraculous if Congress gets its 10th Amendment to any particular statute correct, right? Well, the first thing that comes to my mind when I ask this question is the issue of fees. The provisions that apply in Chapter 11 that give the bankruptcy judge control over fees, reasonableness of fees and the payment of fees, do not apply in Chapter 9. All Chapter 9 says is that as a condition of confirmation, at the very end of the case, the court must find that the fees were reasonable. Administratively, that confirmation requirement is very hard to apply. So if the number one amendment I would recommend to Congress for Chapter 9 is to make those sections regarding fees that apply in Chapter 11 also apply in Chapter 9. Now, you may think that that's a small matter in the grand scheme of things, but it did create quite a lot of consternation in this case after the plan was confirmed. Beyond that, I'm on the fence about whether to recommend to Congress to clarify the confirmation requirements that are borrowed from Chapter 11, but that don't readily apply in Chapter 9, the ones I mentioned. I'm on the fence about it because I'm concerned that A, they'll screw it up and make it even harder to administer, and B, because I think there is something to be said for allowing the bankruptcy judge the discretion to decide what's fair in a given case and what's unfair in a given case, and when there's unfair discrimination in a given case. Because every case is different. And when you start trying to write more specific rules, there's always the law of unintended consequences. Right? So I'm on the fence about more than just fees. Yeah.
Just to ask a follow-up a little more directly, aside from the issue of attorney's fees, are there any aspects of an imperfect law that resulted in you having to reach a suboptimal conclusion in the case? In other words, how did things turn out worse than they should have?
In my judgment, not the party's judgments. Well, as I said in my talk, there were in the end very few substantive legal decisions that I had to make because of all the settlements. Mostly the confirmation opinion was focused on whether the plan could be confirmed despite the rejection of the plan by municipal creditors who were going to receive about 10% on their claims. I did not think that that was a suboptimal result, and certainly not one that required any consideration of any change of the bankruptcy code. I guess the one-word answer to my question, to your question, is no. Other questions? Yes, sir.
I understand that in regard to providing aid to the city residents who are facing water shut, you weren't directly involved, correct? But was there any talk about getting various legal aid groups involved in helping the residents?
Legal aid groups, not that I'm aware of. The ACLU did prosecute their litigation before me, I assume without charge to the people they represented. Beyond that, I don't really know. When I dismissed the case, they appealed, which was fine. I was a little bit surprised that the ACLU didn't take their state law claims to state court. Now, they would have asked me, would have had to ask me for relief from the automatic stay to do that, but I certainly would have been open to doing that. And Section 904, which prohibited me from acting in the bankruptcy case, would not prohibit the state courts from acting on the state law claims. That never happened. Other questions, please? In the back, and then I'll get this.
Yeah, coincidentally, my question had to do with automatic stay, and forgive me if I don't understand bankruptcy law well. I've been a lawyer for many years, but have no experience in there. But and it goes to the gentleman's question about a potential difference in the law or recommendation in the law. It's the automatic stay a great idea when you have a municipality versus a company or individual. It seems that there are reasons for suing municipalities, especially in areas like police misconduct that have been problems in Detroit, that might continue no matter how dire the financial distress of the municipality is, and that there really are consequences when you don't allow a whole range of suits. Did you have any comment on that?
That's a really challenging question, and I appreciate it. To answer your question in one word, I would say that the automatic stay is as important in a municipal case, if not more important, than in other kinds of bankruptcy cases. And the example that I would put forward in support of this answer is one that actually happened in this case. As you may know, at the moment that this bankruptcy case was filed, which was 4:06 p.m. on July 18th, the retirement systems and other parties were arguing in a state court proceeding in Lansing to get an injunction prohibiting the governor from authorizing the bankruptcy. And because the case was filed at 4:06, that proceeding was automatically stayed. Now, even though the judge was advised of the bankruptcy, she proceeded anyway and did enter an injunction, which I later held was void because it violated the bankruptcy code. Without the automatic stay, the entry of that order or one like it would have made the bankruptcy case much more complex and would have multiplied litigation unnecessarily. Now, all the automatic stay does is say to the parties that without the permission of the bankruptcy court, you can't litigate your issues anywhere you want to. If you want to litigate your issues, you litigate them in front of the bankruptcy court, in one central court where the judge has control over all of the issues and all of the parties so that there aren't, for example, inconsistent decisions. So that's all the automatic stay does. It told those people that whatever their issues were with regard to the authorization to file this case. And most of it had to do with the constitutionality of PA 436. They should bring those issues to the bankruptcy court, and they did, and I ruled on them. Now, they didn't get the ruling they wanted, and they appealed, but they all eventually settled. So that's the efficiency that's intended by the automatic stay. But you raise a slightly different question, which is, what happens when, or why should the automatic stay apply when litigation is intended to correct ongoing legal or worse constitutional violations, right? The answer to that is to give the bankruptcy court the discretion to allow that litigation to go ahead. And in fact, I did that. Yes?
It was reported that you took a tour of the city. I was just wondering if you could comment on that and how that sort of impacted proceedings.
Yes, just before confirmation, the city filed a motion for me to take a bus tour, technically under the cases and rules. It's called a site visit, although there's obviously lots of sites. How did it impact me? It impacted me very substantially. I live in Ann Arbor and had been commuting to Detroit for years and years and years, but of course, I was just on the highways. I was not out in the neighborhoods. And I have to say that I was shocked and depressed and sad about what I saw. Block after block after block of blighted and abandoned homes, overgrown, half falling down, half burnt out. No one should have to live in the vicinity of that kind of blight. The impact it must have on the remaining residents' human spirit is just so hard to contemplate. On the other hand, I also saw areas of redevelopment, new homes going up, and that was encouraging. I was also taken to the precinct house for the 9th and 10th precincts, a combined facility, and saw the very substandard conditions that those law enforcement officers have to work under. It was so bad that they had to build a scaffolding over the front door to the building to catch the bricks that were falling off the facade so people wouldn't get hit by them and get injured and sue the city. It was appalling how substandard it was. Yes, sir.
Were there any parties that you felt really kind of were an impediment to moving forward, whether it was like parties to the lawsuit, whether it was creditors, or maybe it was emergency manager or mayor? Was there anybody that you felt really kind of slowed the process down?
No. Parties zealously advocated their positions. Normally, when judges think about your question, what we think about are frivolous discovery disputes. I had very little of that. The parties really did work hard to resolve their discovery disputes. And so I didn't feel that there was any abusive process going on there. The only other way I would answer your question is you may recall that one of the creditors, Soncora, and their lawyers at Kirkland & Ellis, filed a paper accusing the mediators of bias because of the grand bargain and of failing to disclose the connection of one of the mediators to the Detroit Institute of Arts. In fact, that connection had been disclosed in an email that all of the creditors, including the attorneys at Kirkland & Ellis who filed this motion, had received at the beginning of the case. And really asserted no facts other than the result of the grand bargain in support of their claim of bias. I was deeply disappointed in that, and in fact, scheduled a hearing on sanctions for that conduct. apologized for that, and as a result of that apology, I decided to withdraw the threat of sanctions against them. That was the only hiccup in 17 months of zealous litigation. Yes, sir.
Robert Thomas. I'm a 2014 graduate of Wayne Law. As we all know, I mean, of course, we're post-bankruptcy, but City Council has now asked for raises for the council itself. Do you think now would be a good time for such a raise to come in play after such a large bankruptcy?
I really have no comment on that.
Well, do you think the city can handle such raises?
You mean financially?
Financially.
I don't know what raises they're asking for, but assuming they are minimal raises, the city's yearly budget is about $1 billion. So it doesn't feel like a lot of money would be involved in that, but I really don't know. Let's see. You did, yes.
In terms of attitude towards the city, I think people who don't really understand bankruptcy and how it could help a city perceive it as a really negative thing. So what did you do to kind of safeguard national perception of Detroit's filing? And now what can we do to kind of reconcile any bad connotation of the Detroit filing that the nation might see?
At the beginning of the case, there was very little that could be done to address the bad PR that the city had to suffer when the case was filed. In fact, the filing of the case, by the nature of bankruptcy, probably worsened that problem because in the context of proving its eligibility, the city was required to publicly disclose how bad a condition it was really in, how bad a condition its cash flow was in, how bad a condition its debt structure was in, and how bad a condition its service delivery to its residents was in. And it was bad. We're talking, for example, nearly an hour response time to a priority 1 police call. Priority 1 is, of course, murder and robbery and all that really ugly, violent stuff. The national average is 11 minutes. So disclosure of all of this is a necessary consequence of bankruptcy. More recently, I think the bankruptcy has had the consequence of greatly enhancing the city's image around the country and indeed around the world. The balance sheet is fixed, and people who are concerned about that recognize that. It has a plan to restore adequate municipal services over 10 years, and people recognize that. Its credit rating, the 3 credit rating agencies, its credit rating was junk when the case was filed for good reason, and the city is about to go back into the market to exchange some of its debt, and the likelihood is it will be investment grade, and it should be. It's a really good risk at this point. And business people from around the world, especially China, are now competing with Dan Gilbert to buy buildings. So, and of course, there's no greater cheerleader for the city than the mayor himself. If you've ever heard him speak. And I am too, at every chance I get. I tell people how confident I am in the city's future. Question over here, and then I'll get over.
Yes, Your Honor. Justin Hanna. My question was, I was wondering about, there were thousands of pensioners involved in this deal and in the city of Detroit. And, they were represented by numerous groups, who were in turn represented by numerous, law firms. how did that dynamic play out? You know, how did you determine which groups sufficiently represented X number of pensioners and so on?
Yeah. That was a very challenging administrative thing for me. As a legal matter, really no one has standing to negotiate on behalf of the entire pension body. People join voluntary associations of pensioners, and I let them argue. Unions do not represent retirees, they represent employees. And it was for that reason that the city filed a motion to appoint a retiree committee. And I granted that motion. So that committee had the legal standing to negotiate on behalf of all of the retirees. Now, it didn't have the standing to bind them because only a confirmed plan of adjustment could do that. But they could take positions on behalf of the retirees. And the committee members, there were 9 of them, acted as fiduciaries on behalf of all of the pensioners. Now, in this regard, I will say that the pension plans themselves, there were 2, the police and fire and the general, they also had an attorney who argued on behalf of the pensioners throughout the case. That was a mistake on my part. I should not have permitted that. The pension plans do not represent pensioners. They represent the pension plans. Pension plans are created by the city as an arm of the city, really, to carry out the city's obligations to the pensioners. So they're like an agent of the city. They're not really an agent or a representative of the pensioners. This issue was never presented to me by any of the parties in the case, including the city itself. And it was only at the end of the case that I sort of focused on this and figured it out. Let's see, there was another question. Yeah, yes, sir.
Do you think that having an emergency manager in place was politically required in order to file for the bankruptcy, or it was inevitable even under the mayor?
I can't remember if PA 436 is structured so that an emergency manager is in place before the governor is authorized or allowed to authorize the bankruptcy.
No longer. It was the original law required it, but the new law.
So so quite likely legally it's not required. Is it politically required? Well, assuming that the governor is still required to authorize the filing, the request for the filing would have to come from the municipality itself, meaning the mayor of the city council. The law is structured that the governor can file the case for the municipality. And I think that back when this case was filed, it was very unlikely. It was possible to think that the mayor of the city council would have filed this case as necessary as it was. So politically, yes, an emergency manager, at least in this case, was necessary. I also have to think that an emergency manager being in place during the bankruptcy is necessary to the successful conclusion of the bankruptcy case. I cannot contemplate what the negotiations, mediations would have been like if every discussion, every offer, every counter offer had to be vetted through the mayor and the city council. And it's impossible to think about how that would work. It wouldn't have worked. More questions, please. One more in the back, and then we'll conclude.
So having never...
Can you stand up so I can...
Yeah, sorry. So having never presided over a Chapter 9...
Good for you.
What? What was that?
I said good for you. Did you say that you...
Oh, I meant you.
Me?
Yeah.
Yes, I actually had.
Oh.
This was my second chapter.
My apologies. I guess, do you struggle with this, I guess in this case and then the other bankruptcy case, with the fact that a municipality can still, borrow funds and manage property that, you weren't given the autonomy like you would in the Chapter 11. Did you struggle with that?
It's constitutionally required by the 10th Amendment. The 10th Amendment says something like powers which are not granted to the federal government by the Constitution are reserved to the people of the states. So the states have the full responsibility for their municipalities and for the property of the municipalities. And so, although we created challenges in the case, I recognized and tried as hard as I could to respect that constitutional barrier to my authority. All right, let's conclude here. Thank you very much. Your questions are very
Thank you, ladies and gentlemen. For those of you who are in my class, if you could stay for a few more minutes, we just have a few more pieces of business to take care of. The rest of you, I just want to thank you, and I hope you enjoyed the presentation. We wish you a good day.
Thank you.
Last sign over here. I got it. Who walked off? Oh, you have it. Okay. All right. If there are any students that have not yet signed in, would you do it, please? If I could get that. What we saw today, although
You went on vacation, so
the presentation was a little bit out of sync with the rest of our syllabus.
I should be there.
Although it was a little bit out of sync based on the judge's availability. But we're at a point now in class where Wednesday we'll be finishing up Chapter 7, liquidation, and then we'll be starting Chapter 13, and then we'll go into Chapter 11. What you witnessed today, you may not fully understand or fully recognize the context within which it was presented to you, but in the years and decades to come, you may come to find that this was fairly historic. There are a number of other municipal corporations that are in financial difficulty, that are teetering at this time right now. How many of them will have to face or concede to file a Chapter 11, Chapter 9? I don't know. But it's something that was unthought of in years past. If you look in your textbook, you see that the textbook has, I think, maybe a page on Chapter 9, if that much. And that's consistent with the way law school bankruptcy textbooks have always been set up. 40 years ago, when I was sitting in your chair, we were in the same position. The textbooks that I used had nothing whatsoever about Chapter 9. History tells me that we have had about 500 Chapter 9 cases throughout the United States history. 500 cases is really not very much. It doesn't give anybody an opportunity to develop a body of law, a thought process, so on and so forth. For those of you who may have done the reading at the administrative U.S. Court's website, you may remember that there was some statements in there that indicated just how limited the court's authority was. And some of that came out in some of the presentation that we talked about today. The court's authority in a Chapter 9 case is far more restricted than it is in any other form of bankruptcy. Apparently, it was designed purposely in that fashion for the 10th Amendment reasons as well as for political reasons as well. But the idea behind it is that the judge would kind of be available when the parties agreed to submit disputes. That didn't mean that the judge was going to shepherd the case through the court system. It certainly didn't mean, as Judge Rhodes mentioned, that any pedal would be put to any metal. Clearly and obviously, it's an amazing contrast between theory and practice. In theory, the way the code is set up for Chapter 9 are really quite different from the tactic that and the strategies that Judge Rhodes implemented. There are pending Chapter 9 cases elsewhere around the country that were filed before the Detroit case, and they're still pending. What will the results be? We don't know. Some of the questions earlier this afternoon hinted at or asked and inquired of what would have happened had the city's case plan not been confirmed. Of course, that's a matter of pure speculation for anybody, but you could kind of answer that question yourself simply by knowing what you now know about what poor shape the city was in, and asking yourself, well, what if there were no financial relief? What would happen at that point? We have a city that geographically is the size of Boston, San Francisco, and Manhattan combined, and yet the population of those three cities are probably 5 times what the population of the city of Detroit is. No matter how you do the math, it pretty much well does not work. A redo is what was necessary, and that's what the Chapter 9 case was. But as we start getting into Chapter 13, and as we start getting into Chapter 11, you'll see that there's also case management theories that come into play. One of the things I've tried to impress upon you is that it's in order to be successful in your endeavors that are legal in nature, you need to understand the law, to be sure. There's no question about that. But if you only understand the law, then maybe you're best off coming back here and taking a teaching position. Because in practice, when you have a client that's looking to you to achieve goals and to try to find answers and to resolve issues, you need to know more than simply what the law is. You need to also be involved, as Judge Rhodes said, when do you litigate, when do you mediate? You have to have both tools available to you, but you also need to have wisdom and discretion to know when do you invoke one or when do you invoke the other one. So we'll see as we get into it, we'll be able to enhance your knowledge of the various other chapters by contrasting one chapter with another chapter. Chapter 7, we spent the bulk of the time on in the semester. Chapter 7 is the point of reference for everything that we do in bankruptcy court. It was interesting to me, particularly, that Judge Rhodes flat out said the art collection was never at risk. I don't know how many of you were following the city's case in the media. The media squarely told us that the art collection was at risk. Did they not?
You get appraisal for it, what it was worth, how much was then, yeah.
Why?
Scared of it?
I mean, if you didn't have all the philanthropy involved, you wouldn't have that.
So, yeah.
Well, it was, too, there was a conception that the art collection was property of the city.
Which it was.
Well, and the idea is, well, if they're discharging debts, how are they allowed to hold on to valuable property?
Well, as you will find out, when you become a lawyer and you become a legislator, you're the boss. You get to do whatever you want. You can make the law. It's good to be the boss. Other questions, other comments about what we had today? Any thoughts about what was going on? Anything you heard surprise you? Anything you... What part of the pension purchase? Yeah, and that there were those couple state Supreme Court cases that talked about it as a pension obligations as contractual obligations. And that's what some of the things you've heard me make several comments in during the course of the semester. We impair contracts all the time. There are value judgments that will come into play, that each one of you will have your own opinions with regards to this, and certainly I'd love to hear it, and certainly we should all be respectful of each other's opinions. But there will be some people that will say that from a political or a political science standpoint, that there were certain presumptions that were made when the bankruptcy laws were created. We can break contracts, but we have to respect property rights, lien holders' rights, and things of that nature. That might not square with everybody. That may not be everybody's political cup of tea. Somebody else had a... Yeah.
Just to touch on that, some states view pension rights as property rights. So in states like that, I mean, what kind of precedent would this set?
It certainly made things a lot easier, I think, for Judge Rhodes. I mean, he's still limited by, even though he's retired at that point, there's still a sense of judicial ethics that bar him and prohibit him from fully disclosing or talking about certain things. But Michigan law, having Michigan law speak of pension rights as contractual rights, certainly made his job a little bit easier. There's no question about it. How it would happen if we were in another state, or if the state of Michigan state law were different and referred to them more as property rights, I don't know. I'm not so sure. But I think you can also take a look at that entire grand bargain. That grand bargain, part of the grand bargain was raise money for those who prize the art, and in effect give that money to the pensioners. And as some of you said, maybe that this was wholly done, maybe this was an orchestrated thing in media, using the media for purposes of trying to generate that additional revenue. I don't know. I don't know enough about the case to answer your question. I know that there are state constitutional protections, but then again, as Judge Rhodes mentioned, that may have flowed downhill. And it may have turned out that the Detroit pensioners may have wound up seeking redress against the state. Maybe the state just simply guaranteed it, and they acted as a guarantor. And again, you can kind of see that in some of the cases we've looked at in Chapter 7, or discussions about the automatic stay. Can if a debtor files a Chapter 7 or files a bankruptcy case, and the creditor is stayed from seeking collection from the debtor, but if somebody else co-signed or guaranteed the obligation, the creditor can still go after them. So again, you can extrapolate from small consumer cases where the facts oftentimes are more familiar to us, where we can make sense and we can better identify it, to something like a Chapter 9 case where it's a little bit more unusual. A lot more. Other questions or comments about today's presentation? I'm sorry that we couldn't get it set up. I wanted originally to get Judge Rhodes to come around the time towards the end of the semester. That would have given you folks the exposure to Chapters 13 and Chapter 11. His schedule didn't permit it, so this is the first time that I could get, this is the latest time that I could get him to come in and get it.
Comment, it seems now the big issue is the feasibility of the plan, because,
It was then too.
as a potential practitioner, it seems to me it would be pretty disheartening to see the debtor client, in financial troubles right after the discharge in bankruptcy, and especially now that we're hearing that Wayne County is in far worse shape than we previously thought, and I'm wondering if that's going to affect the city.
Well, sure, in one fashion or another, it has to. This is something that, and again, as I was referring to, we can see this in the Chapter 11 context, a little bit less so in the Chapter 13 context, but a corporation is able to get its plan confirmed, and they're able to convince a judge that their plan is feasible. And then a few years later, that same company comes back into Chapter 11. This case with the city is real and in your face, so to speak, because I think that's a question that you raised, Mr. Taylor. It's on everybody's mind. After having learned what we've all learned about the state of affairs of the city of Detroit, can they pull it off? Is it going to work? They've got all the experts that have come forward that have testified that the city of Detroit's plan is feasible. The judge even went to the unusual extreme of appointing his own expert, not an expert brought in by a particular party. And that expert said, yeah, we think so. We're not real confident, but we think so. But really, will it work? Some of you may wind up being involved maybe in the city of Detroit too in 20 years. Who knows? We just don't know. But you look around the classroom, you look around the law school, and you have to wonder which of the students in this school here at this time will be the people that will be involved in those types of things. Our other legislators didn't play a direct role in this, but of course they were keenly involved in it. They wanted to be advised of what was going on. They certainly played a role in the background. Which of you will be doing something similar decades? Other questions? Any other observations or comments about today? What questions would you have wanted to ask me?
About the transparency and opening up federal court, district court to be televised or recorded.
He made reference to the Judicial Council. The Judicial Council is an organization of federal judges that is headed by the Chief Justice of the United States. They set policy, and basically they would tell a guy like Judge Rhodes, this is how you're going to do it. You're going to open up your courtroom for audio or for visual, or you're not. Or there's going to be test pilot projects in different places around the country. The Judicial Council has said, and the federal arrangement, the federal judiciary is very different from the state.
Yeah, I mean, the state's fully open.
The state is fully open, and the state also has popular election of judges. In other states, we have more, not so much a popular election of judges, but maybe a ratification of a gubernatorial appointment of judges. In Maryland and in Massachusetts and places up and down the East Coast, a person may be appointed judge for maybe a 15-year period of time. They usually don't serve more than 2 terms total. And it's usually just a referendum on that particular judge. So the states seem to be far more open, far more willing to abide by the will of the people in their selection of judicial officers, as well as access to proceedings. But everybody, all of you, everybody, was certainly eligible to come into Judge Rhodes' courtroom and watch the proceedings. But it wasn't being webcast.
Yeah, I mean, it's eligibility versus practicality. It's one thing to be, take a whole day off to come to the city and watch all the motions and on the spot and stuff that goes on. And they condense it down and put it on in a televised format. It's really nice.
I would imagine that at some point, it would be interesting if anybody, any academics ever received any grants to do exactly that. Because the volume, one of the biggest worries that everybody had when oftentimes when large cases are filed, bankruptcy cases are filed, GM, Chrysler, so on and so forth, the practitioners in the Detroit area were initially upset at GM and Chrysler when they knew that they were teetering on filing, because they knew they weren't going to file in Detroit. And the Detroit lawyers were upset that they were cut out getting involved. The judges were thrilled that they were going to file in New York, because when a large case like that is filed, including the city of Detroit case, the bankruptcy court here in Detroit doesn't have enough servers to handle all the data. They actually had to go out and get a special grant from the court system, and they got hold of servers, I think in Washington, and when you wanted to log on over the internet to find information about the city's case, you didn't go to the court's website. You had to go to a separate website to do that. Things that we don't talk about in academia, things that don't get discussed because it's not in the statute books, it's not in Title 11 or things like that. Those are the things that you have to be mindful of, whether you're a practitioner or a jurist, because those are things that are going to make or break the daily routine and stuff like that. Nobody wanted the court's website to crash just because so many people were coming to visit it. In a similar fashion, too, just if you did have access over the web to all of these pleadings and stuff, you don't have a tour guide. There's no role for a tour guide in one of these legal processes to explain to you what's going on. It's not like you can go into a museum, take a tour, they can explain this dinosaur came from this era, so this whatever, all the different artifacts came from different places. They don't have that in the court system. So you walk in, you're in the middle of something, they're in the middle of something, you have no idea what it is, you have no idea how long it'll be going on. I'm sure that Judge Rhodes consulted with other judges who had had bankruptcy cases. I'm sure of that. They opted for one approach, he opted for a different approach. Time will tell which is the better approach with this type of stuff. Other questions? You've all signed in? You got that? Okay. Wednesday, we're going to finish up with Chapter 7 liquidation, and then a week from today, we're going to start reorganization. The balance of the semester will be spent on reorganization. Thank you.